Okay, let's bring back in criminal defense attorney and former prosecutor Susan Williams and civil attorney, also former prosecutor Eric Davis, joining us once again. I'm sorry, Kirk Davis. I'm sorry, Kirk. Listening to that, this handwriting specialist testifying about that note found in the defendant's vehicle, how does that jive with this whole alternative theory that it was someone else in his car using his multi-tool?
Is that one for me?
Yeah,
Sorry,
please, Kirk.
Again, this is a tough mountain to climb, and usually, the burden, of course, is upon the government to present the evidence, and they've done appears to be a compelling job. And so now the spotlight is on the defense, and what do? I guess you say, were any of those items actually used? Could there be an innocent explanation for those items that are on that list? So that's, but it does raise the point which Susan mentioned earlier, which is where are the experts? Certainly, if you wanna get at that, perhaps you want to call a handwriting expert, because that's one area that a defense could make a lot of inroads.
Yeah. So, Susan, you've been talking a lot about motive, and what would a possible motive be? I thought, and this is just one theory. I thought, well, maybe the defense could try to say that, and again, don't judge it. But a viewer did comment this was self-defense, that he was acting in self-defense because she reacted in some way when she discovered that she was in the wrong vehicle. I mean, is that a possibility?
With that note and that handwriting expert, absolutely not. This is another compelling piece of evidence from the prosecution. I was waiting for that on that list, on that note, for them to say, black duct tape, dark clothes, what was it, matches. This is premeditation. That should be one of the things on the list, because that's exactly what this list is. It is the smoking gun, and that handwriting expert from the state just tied this defendant to this list. And guess what? Some of these things were applicable to this case. He was wearing dark clothes. It seems he did not get around to the gasoline and matches, but maybe that was something that was part of his premeditation. But to find a handwritten note that directly ties this to this defendant, that's something that is a real gift to the prosecution and a major problem to the defense.
But Kirk, if it's premeditated, then why would the defendant be so sloppy as to basically have the victim's blood all over his car, even at the time that he's pulled over, some 18 hours later?
Oh, that's a great question, Joy. And that's one you get asked, right? And my answer to that is the prisons are full of people that have made mistakes with crimes. And, just because there may be an element of premeditation doesn't mean that it was exactly carefully thought through and all of the loose ends sort of tied up, all of the incriminating evidence destroyed. Just because he may have planned part of it doesn't mean he was completely successful.
Okay, Susan, so looking at everything that we know that's on the table, and frankly, what you commented was surprising, that the defense did not present any witnesses at all. What do you think we can expect tomorrow?
What I can expect tomorrow from the defense is trying to take everything that we've listened to and package it up into a neat theory that we can all understand, because we have a lot of questions, and that may very well be their strategy. The state, I know that Solicitor Gibson is going to knock this one out of the park. He has so much evidence. I would go through it one by one. I may even do like a visual where I would check off each piece of evidence or stick a Post-it pad on every single time there's a piece of evidence that we have, there's another piece, and then by the end of this, the little white tablet behind the witness stand, you have all these Post-it notes, and then you do all of this in front of this table full of these brown bags. I mean, that is just an overwhelming pile of evidence. And, I really think that these are going to be some of the most compelling closing statements tomorrow. I really cannot wait.
Yeah. So, Kirk, obviously, what we've discussed is that the defense is going to have to really push this idea of reasonable doubt, right? And as Susan has been pointing out, there is this whole mountain of evidence. One thing that I noticed was that the defense, during cross-examination, kind of was going with this narrative of, okay, so you, expert with State Law Enforcement Division, did all of this thorough investigation. You followed protocol. You wore your gloves like you were supposed to. You made sure that the evidence wasn't compromised or contaminated, and yet you didn't find our client's DNA on the victim. So is that narrative, you think, what they're really going to hammer home tomorrow, and how effective might that be?
I think that's exactly right, Joy. I think it's basically all they've got. I think it's going to be hard for them to present a coherent, single, unifying theory of the case because they haven't really got the witnesses to put that forward. So it's going to be a question of just sort of trying to uncouple the links, if you will. So as Susan mentioned, there's this pile of evidence in front of the jury. And then the defense's job is going to have to say, okay, yeah, there's that. But how is that specifically tied to our client? How does that really show that it was him that acted upon these things? And so that's what I would expect.
But in your experience, obviously, we know that the burden of proof is beyond a reasonable doubt. In your experience, Susan, is it really necessary to come up with an alternative theory rather than just count on reasonable doubt in cases like this?
Well, I think that you go back to I keep talking about this, the empty chair theory. I mean, no, I don't think that you need to have necessarily a plan that said this happened and this happened and this happened, and all of this means it does not point to my client. But I do think that it's important for the jury to see, okay, we don't know who it was, but it was this person in this chair. It's an empty chair. Whoever goes there isn't the defendant, and that's the point you drive home.
Okay, Kirk, I have another question for you. We know that South Carolina is a death penalty state. Even though there's a moratorium on the death penalty, it can still be issued. It is still a sentence on the table. However, in this particular case, the maximum sentence, again, maybe we're jumping forward, is life in prison. So my question to you is, from the outset, why wasn't the death penalty even looked at as a potential option should a conviction be achieved?
Wow, that's again a great question, Joy. That's one of those questions that is for the elected or the chief prosecutor in that jurisdiction to come up with a policy for the office, because that's something here in Washington State, here in Seattle, in King County, which is the biggest county in the state and where Seattle is, they basically taken that off the table. And the governor in our state has issued a moratorium on that, just upon the basis of looking at, is it fair? Has it been applied fairly without discrimination across the board? And a lot of people have looked at that and said, you know what? This hasn't been fairly applied, so we're not going to do that here in the future in our state. I don't know if that's what the calculus was there, or if there's some other calculation involved. Yeah,
we're going to, of course, keep an eye on that as we continue our coverage of this mistaken rideshare murder trial. Also ahead, the next trial that we're covering here out of Court TV is in West Virginia. So we're going to hear opening statements from the state in the deadly neighborhood